This is a unique podcast exploring the criminal justice system and those involved and affected. We'll educate and expose the public as well as potential jurors to what takes place behind the scenes of those who are facing the system. Your host owns a litigation support firm called Justice Technology Professionals, and he works on criminal and civil cases offering support to defendants and counsel. What you're about to hear is an open dialogue, opening the minds to the public to what takes place in reality as opposed to what you think takes place. Ladies and gentlemen, welcome to the Justice Tech Pros podcast. Here's your host, Dominick Crea.
Hello, listeners. As always, hope everybody's doing well. Today I'm going to dive into a couple topics and areas of discussion that I believe everyone will find interesting and give some food for thought and a few things to think about. The first one that comes to mind, I was watching something on the news, and there was a lawyer talking, and he brought up a point, and I'm actually going to play some clips today from various things and then discuss my opinion on them and what I want to extract from them to try to relay a point I am trying to make. So I'm going to play a clip, and then I'm going to elaborate on it and just go into my train of thought, how it relates, and expand on it a bit. So here's the clip I want you to hear first. This is from a lawyer. His name is Bruce Castor Jr., and he was actually Trump's defense lawyer, and this has nothing to do with politics. I'm going to focus on the point that he's making with this statement. It's irrelevant about him being Trump's lawyer. It's irrelevant as far as relates to impeachment. Not getting into any of that. I just found what he said to be very interesting and where it could be applied and where it does actually take place. So I'm going to play that for you to listen to.
And if one of the lawyers was able to create the impression that one side intentionally presented false or misleading evidence, that judge would give an instruction called FALSUS in UNO, FALSUS in OMNIBUS. False in one thing, false in everything. In other words, if they're trying to fool you about one thing, not only might they be trying to fool you in something else, but under that maxim of the law, you may conclude they're trying to fool you in everything else.
So here the attorney is actually citing a legal principle, falsus in uno, falsus in omnibus. And it's a Latin phrase. And as he says, it basically means false in one thing, false in everything. And the reason why I found that extremely interesting is as it relates to the last case I was involved. There was times when the defense, not once or twice, but several times, where the defense proved what the prosecution was saying was false. It was misleading statements. It was inaccurate. So by that theory and by that legal principle, one would figure it would follow through, where if they keep making these false and inaccurate statements and misleading statements, everything they're saying is false. And again, what played out and where I kind of have the issue, well, who determines that? You know, if you're proving that something false was done, not once, not twice, several times, wouldn't that alone prove that it is intentional and anything thereafter should be factored in, that they're trying to intentionally make these false and misleading statements? And again, that's where it goes back to the judge. The judge could basically either adhere to this legal principle and enforce it and go down the path of saying, well, that's not, you keep saying things that are inaccurate. The defense keeps proving that they're not true. You're making statements that are not in line to what the evidence that you're telling us suggests. The evidence doesn't suggest that. It doesn't exist, which we've shown time and again. So the judge should then look to rule based on that and look to say, well, now everything is false. We can't really believe anything that you're saying, and start to really dive into, that's where it opens the door of diving into the grand jury minutes and seeing what was inaccurate from inception. But here we are again, where you have something that is a legal principle, but could pretty much be kicked aside if the judge just doesn't want to adhere to it. The judge has the power to either follow through on it, to see the rationale that the defense is saying, look, Your Honor, once again, the statements are inaccurate. Once again, they're misleading. Once again, they're false. What are we going to do about it? And a judge could simply not do anything about it. They could chalk it up to, they like to use that term, harmless error. Well, when does it stop becoming harmless error, and when does it fall under this phrase where it's false in one thing, false in everything? When is that determined? What's the threshold for that? Is it 2 times, 3 times, 4 times, 5 times? How many times do you have to prove what they're saying is not in line to the discovery or to the evidence? And if you go through it during the pretrial phases and you prove it time and again, you're not just... We're not talking about, especially from the examples I'm given, I'm talking concrete examples which are supported by motions, supported by court documents, where we're showing repeatedly what they're saying at certain bail hearings, evidence they're saying that they have, evidence that they're saying they possess, doesn't exist. Or it's just not true. They're saying one thing was said on an audio tape that was never said. Regardless, to keep it more general, I'm using a specific example, but to keep it more general, if the defense keeps pointing out these inaccuracies, when is the threshold met, whereas it can no longer be chalked up to harmless error? And now it falls under the definition of this legal principle, whether intentionally or even if it's unintentionally. I don't really think it matters. My point is, if it keeps happening, that's a problem. If they keep repeatedly saying things that aren't true, saying they possess evidence that they don't possess, just to make the case appear stronger during the pretrial phases, whether it's to get defendants bail revoked or not approved or not give them bail, whatever it may be, when you're going through the pretrial phases and they're using these arguments based on discovery that doesn't exist, based on testimony that's not accurate, that you're able to prove is not accurate, once you start getting that rolling discovery and you start siphoning through it and uncovering the different audios that they're supposedly citing, and when you're matching it up, none of what they're saying was on these audios is there, or nothing that they're saying is in the evidence is there or exists. So now when the defense does their homework, does their investigation, does their reporting, puts it all together, puts in the motion showing that at bail hearing for one defendant, the prosecution said X, Y, and Z existed. It doesn't exist. The prosecution said this statement was made on an audio and was recorded by this defendant. Doesn't exist, never happened, wasn't on an audio, was never made by the defendant. The prosecution says, Your Honor, we have this document. This is why you should not give this defendant bail. And in this document, he says A, B, and C. Now the defense comes and say, no, there is no such document. Doesn't exist. When does that start to mean something? Outside of just being shooed away as nonsense, where the judge pretty much says, harmless error, okay, proceed. And that's the theme that carries over on all my episodes. There's a lot of law and things sounds great, and a lot of these things sound great the way they're written. This statement alone is very commonsensical, and it makes a lot of sense. It's something that the general public would relate to, and I think that any reasonable thinking person would agree with. If somebody tells you something false once, twice, a few times, you have to start believing everything they're saying is false, right? But now if you have a judge who doesn't want to go by that, doesn't want to apply that legal principle, they could dismiss it. They could chalk it up to something that wasn't intentional, and even though it was false, they didn't mean for it to be false, they were misinformed. And once again, that room for latitude is just too great. They have all of these clearly defined laws, rules, legal principles, whatever you want to call them, but what good are they if they're not followed? What good are they if they're not enforced? Here you are as the defense. You're now doing your homework, you're doing your job, you're uncovering these things, you're showing the inconsistencies, you're showing the contradictions. You're showing that what they're claiming is not accurate. And then when it comes time for a ruling, it means nothing. How disheartening that is for the defense team, for the defendant. One would think that's pretty cut and dry. If they're claiming to have something that's so strong and works so heavily against you and is really damaging to the defense, and then the defense goes back, goes through everything, uncovers what they're trying to cite, shows that it's nothing like they're saying it is. They don't possess what they say they have. What they say they have doesn't exist, or it does exist, and it doesn't even portray in any way, shape, or form what they're claiming it does. They're saying that something says it's black, but yet you're showing it's white. Complete opposite things is my point. Now you show that, you put in the motions to show that, you give the examples to show that, you give the backup to show that, and it means nothing. The judge doesn't apply this legal principle. The judge doesn't then step in and give the instructions, as this lawyer said, where he'd give the instructions of falsus in uno, falsus in omnibus. Doesn't even come up. And that's where I have this disconnect from internal common sense, how things should work. When you have a rule, when you have a law, and it's broken, it's not followed, there's a principle to back it up, you're showing that you have now met that threshold. You have now supported your claim with factual information. It's not one argument. It's really not a he said, she said. You're showing factual information, and they admit it. The other side will admit it, and they will say, oh, we were misinformed. Let's say it's a witness made an incorrect statement. He was confused, which is basically an excuse, right? Because obviously no one's going to say we intentionally lied. We intentionally, and again, it may not be intentionally. They may have been lied to, so they may be presenting something that they thought was true. Maybe the witness lied to the prosecution. Maybe the witness lied to law enforcement. I'm not assuming that they're lying. I won't say that. I believe, I'm sure a lot of the prosecutors, a lot of law enforcement, they're just trying to do their job. They're just trying to go by the law. So maybe whoever's giving them the information isn't giving truthful accounts. So they're just repeating that. But now here's where I have the problem. You show that. You show that somebody's being dishonest. And then when it gets brushed aside, that's where I think there's more at play then. That's when I think, well, maybe the intentions aren't just to fight a case, just to present a case, and just to go by the facts. That's where I start to think pieces are pulled to try to fit in, square pegs are try to put into a round hole just to make things fit for a bigger agenda. And it's hard not to think that way when you're looking at something in black and white that is an out-and-out inaccurate statement. It's misleading, it's false. You've proved all those things, and yet it doesn't mean much. It gets pushed aside. This legal principle is not even brought up. It doesn't matter that there was false in one thing. Doesn't matter that you could cite this and you could say, Your Honor, shouldn't that automatically say false in one thing, false in everything? We've not only showed it once, we've showed it twice, we've showed it 3 times. Doesn't this amount to something? And unfortunately, sometimes it doesn't. I haven't done enough research to see what judge may have implemented this or used it, but I know where I was impacted directly, where I was helping on a case, it wasn't done. The judge just kind of brushed it aside. And again, this isn't an opinion. This is actually things that transpired. That could be pulled up, that could be read in the trial minutes, in the motion submissions. You could see it play out. You could see, if you pull different hearings, pre-trial hearings, whether it was a bail hearing, whether it was a motion hearing, claims that were being made in court by the other side, by the prosecution, wound up not being accurate. All based on saying they had a statement, they had an audio recording, they had somebody on tape saying something, and then when we proved, well, that's not true, that never happened, they don't have these things, that never took place, one would think you just had a major victory. You were just able to prove something wrong. And then when no positive result for the defense comes of that, I tell you, the wind really gets taken out of your sail because, well, what's the point? What's the point of fighting it then? What's the point of uncovering it? Why go back and do your homework? Why go back and investigate it? Obviously, you're not going to stop, but I'm just saying it makes you start to question those things. And I find it hard to believe, let's be real, if the defense did things like that. Let's say the role was reversed, and every time the defense came into court, they kept saying things that just were not true. They just kept saying things that were inaccurate, and the prosecution, the state would come back, and they would prove the defense was wrong, the defense was lying, the defense was saying things that just were not accurate, were not true. What do you think's going to happen? Do you really think the defense would get a slap on the wrist? Does anybody really think that it wouldn't be that big of a deal? And I think what's most frustrating, the jury obviously never sees any of this stuff. They never see this take place. This is all pre-trial stuff. Imagine you could paint that picture for a jury. You could walk them through what took place. Because that won't even make it into the trial. You can't revert back to that at the trial. You can't say, well, we presented this motion and we proved the prosecutor was lying at this time, at this bail hearing, and we lost the motion, but yet we proved they were lying. Ladies and gentlemen of the jury. And then say, as the defense attorney, you want to use this legal principle. You want to hit them with this Latin phrase. You want to let them know that there is a legal principle that says false in one thing's false in everything. You can't bring that up. You can't talk about pretrial stuff. You can't talk about how you caught the prosecution in a lot of errors and a lot of misleading statements, and what they may have said at the grand jury doesn't line up to what was given in the discovery. You can't even talk about that. And what's more frustrating, and I did a whole episode on this with the grand jury minutes that I spoke about on the federal level. On the state level, you get the grand jury minutes, so that's a huge benefit because you could really do a lot of compare and contrast with that. You could show the discovery versus the grand jury to see how the indictment was issued. But on the federal level, you can't even do that. So at the very least, one would figure if you're showing time and again inaccurate statements being made, any judge for themselves, even if they don't want to give the minutes to the defense, the judge would want to look at the minutes in camera, which in camera means the judge is going to look at them by themselves. They're going to review the grand jury minutes and they're going to compare them versus what they have in front of them versus the evidence and the discovery that the defense has brought to their attention. You would think a judge would want to do that if you keep time and again proving it. But as I talked about in the past, for some reason getting those grand jury minutes is like catching lightning in a bottle. Judges do not want to grant that motion. They do not want to allow the defense to see those minutes. And I really wanted to just touch on that because I think it's an important principle. I think it's an important statement, even if you don't remember the Latin phrase of it, the falsus in uno, falsus in omnibus. Just remember the in layman's terms, false in one thing, false in everything. So if somebody's telling you something inaccurate, you have to almost believe everything they say is inaccurate. And that could carry over a lot. That could carry over on the witness end as well. You have an informant who is caught lying, who has committed perjury in the past, who has told stories in the past, who have said inaccurate things in their proffer sessions in the 3500s. The jury should think about that. They should think if they're on the stand and they got caught lying about something, or it's blatant that they're lying about something, they really have to start thinking that everything they're saying is false. And that's why I bring these things up, because, again, I know it's not going to change what I'm talking about as far as proceedings go. I'm not naive. The only change I'm hoping for, and the whole reason I try to do this, is because the power is with the jury. And if we can have some jurors serving that have these things in back of their head and understand these concepts and understand a bit of a wider picture, and they have examples, and they could think back to what I spoke about. And even though it may not be specific, and they don't have to know the case I'm talking about, they don't have to know about the instance, they could just think about the grand concept of it. And if that just helps them look at the case a little differently and look at it with more of an open mind and more of an investigative mind and use their common sense, that's the only shot people have for a much more fair trial. Because unfortunately, as we know, a lot of people get wrongfully convicted. There's a lot of exonerations years down the road. And I think everybody across the board would want to prevent that. You don't want somebody going to jail who doesn't deserve to go to jail, somebody who's innocent. That's not what the system is set up for. Innocent people should not be going to jail. So how do we prevent that? The jurors have to be a little more educated. And when I say educated, I'm not saying more intelligent, I'm not trying to insult jurors. What I'm saying is the average person doesn't know these things. I wouldn't know these things if I wasn't involved in it, if I didn't research it, if I didn't look. I would have no idea about these things. So you just want to hear a little bit more and be a little bit more prepared. And that's what I try to do, just prepare the jurors a little bit. Just give them a little background, a little foundation of how these things work, so they could pull on that. They could pull on that knowledge when and if the time comes for them to serve. And that kind of leads me to my next segment, the entire basis of a juror and a jury, individual juror having the knowledge, having the foundation, and being able to make decisions based on that, and being able to understand what's being presented to them and trying to grasp the greater picture. And what goes hand in hand in that is a juror needs to be self-confident, and they need to stand by what they believe in. And I was watching this episode, I believe it was on 2020. It was about a lady, her name was Margaret Rudin, and she was convicted of killing her husband, which she didn't do. She served 20 years, this lady, and then she wound up being free. They proved that she was innocent. You know, this poor lady did 20 years. And what's crazy, they offered her so many pleas, which she would have been out in like 5 years. It was a lot less time, and she wouldn't take it because she just said, I'm not going to admit to such a horrible crime like that of killing my own husband when I didn't do it. And it took her 20 years, but I don't want to focus so much on that story. I just want to focus on, there was a couple clips on there, and I'm going to do something a little different this episode where I'm going to play certain clips because in different shows, and specifically in this show, they hone in on the point that I'm trying to make, and they just gave me the topic of conversation I wanted to focus on today. The clip I'm going to play you now is this one juror, she was the holdout. She did not believe Margaret was guilty. She believed she was innocent. And she was so much of a holdout that the jury foreman actually complained about her to the judge. And this is the judge talking about the jury foreman complaining. I just want to play you the clip, and then I'm going to talk a little bit about it.
The foreman wanted me to dismiss juror number 11 because she was the only holdout. And I said, no, our actions weren't such that she needs to be excused. And if it's going to be a hung jury, so be it.
So now here you have a jury foreman, okay? He's complaining to the judge because one lady will not vote the way the other 11 are. She doesn't want to vote guilty. She wants to vote innocent. So being she wants to vote innocent, this jury foreman goes to the judge and wants her thrown off the juror. Imagine that. Thankfully, the judge basically said, no, I'm not throwing her off. If you're going to have a hung jury, so be it. Have the hung jury. But think about that. Think about the pressure that this lady must have had in that jury deliberation room. And I guess everybody's built differently, but I couldn't care what kind of pressure I'm getting. If I believe something and we're going to go to war, then we go to war. You're not going to force me to make any decision I don't want to make. And that's what ultimately winds up happening. And that's really bothersome to me, and I'm going to play you that clip as well. So now you have this jury foreman who's basically being a bully in the deliberation room. He's intimidating this woman. He's forcing her to change her plea, and inevitably, her vote. Forcing her to change her vote from not guilty to guilty. And inevitably, this guy wins because he's bullying her. He has like a strong personality. You could even see on the show, he's one of those arrogant guys. And he was probably just bothering this lady. And it went on for days. She tried to hold out. But I got to say, I'm a little disappointed. And that shows to me, which people need to be aware of. Look at that. You have somebody who doesn't believe the defendant's guilty and winds up switching their vote solely on being pressured. You're ruining somebody's life because you were pressured. I have a serious problem with that juror. She was trying to get sympathy on the show, and I don't feel bad for her at all. I mean, stick to your guns. This is a woman's life. You just ruined this woman's life, even though you didn't believe she was guilty because you just gave up. You couldn't take this jury foreman pressuring you. Somebody with that kind of character, honestly, they shouldn't serve on a juror. And it got me thinking, I don't know, maybe they should have some kind of mediation, a mediator in the jury deliberation room. A representative of the court maybe, or an independent party. I don't know, but somebody to prevent jurors from getting bullied, from getting pressured. Because if that's what takes place, God only knows how many times that could go on. Where you get somebody of a weaker character. They're not a leader. They get intimidated. They allow other people to make decisions for them. They don't want to stand up for what they believe in for whatever reason. Some people just don't like conflict, and I understand that. I get it. But in the legal system, there's no room for that. You're dealing with somebody's life. There's no room for that. And maybe to enforce that, there should be some kind of mediator, some kind of mediation process. Somebody to step in and regulate things, not allow a juror with a stronger personality to dominate the conversation, to dominate the deliberation, and then force people and pressure people to vote the way he or she wants to vote. That shouldn't be allowed. And I'm going to play you a clip of what happens. You actually hear the foreman reads the verdict of this individual being found guilty. You actually hear the juror cry. And then she talks about how she mouthed to the defendant, "I'm sorry." Which blows my mind on another level. I don't know how that's not an automatic mistrial. I don't get that, but I'm going to play that clip because it's kind of infuriating. This is somebody's life you just ruined because you didn't have the backbone to stand up to this jury foreman, but I'm going to play it now.
When the verdict was read, you hear somebody sobbing. That was me. Because I caved. And all I could do was look up at Tom Patero and Margaret Rudin and mouth, I'm sorry. I'm very ashamed of myself that I let that happen. It's the biggest regret of my life.
So now, in her own words, she said she caved. She caved, and some lady now who wound up being innocent, who she felt was innocent, lost 20 years of her life because she caved. Now, I'm sorry, I don't care how remorseful you are, how upset you are. There's no excuse for that. You just ruined this lady's life. You need to stand up. You're going to serve on a jury. You better have a backbone. And if you don't believe somebody's guilty, you better fight tooth and nail, because you're going to end somebody's life. You're going to end their family's life. And I found that so frustrating that, she was sobbing and she felt bad. Yeah, that's great. You feel bad. Meanwhile, this lady's going to jail. And who knows how many times that happens. This is one instance we're hearing about that happened to be spotlighted on 2020 or Dateline, one of those shows. This is one example. Who knows how many times that goes on? Who knows what goes on in the jury deliberation room? Who knows how many times somebody just switches their vote because they're sick of fighting? Now, me personally, my personality, I can't relate to that. But that doesn't mean anything. I understand I'm one way. Everybody's built differently. I recognize that. I understand that. But here's the problem. How do you counteract that? There has to be a check and balances then. People have to allow for that. The justice system has to allow for that. And the only way I could think of is, as I said, possibly having a mediator back there to prevent these type of things. Somebody to make sure there isn't one or two individuals dominating the entire deliberation process and the entire conversation that goes on. But there has to be a way of preventing that. Allowing these things to go on cannot be the answer. Allowing jurors to quote-unquote cave cannot be the answer, to just go with the flow because they don't want to fight anymore. Lady just lost 20 years of her life. She missed out on her kids, on her grandkids. She came out a great-grandmother. All because this juror, if this juror would have stuck to her gun, she would have got a hung jury. And then who knows, maybe next trial she would have got justice. But because this juror caved, that's that. And who knows how many times that happens. It makes one think, do you go now and talk to the jurors? Do the defense team, when you lose a trial and you know your client's innocent, do you get an investigator to go talk to all these jurors to find out if somebody was influenced? Start to think about that. It's giving me some ideas anyway. But you start to think about that. Maybe it makes sense to see what went on in that jury room. Was somebody influenced? Was somebody pressured? Those are things that defense attorneys, appeal attorneys have to think about. And defense teams have to think about. And as I said, it's giving me something to think about on cases I'm working on. But my point is, if that happens, what stops that? What prevents that? Nothing. Nothing, as of now, nothing's going to prevent that. You have a bunch of arrogant individuals who don't let other people talk, who have the mentality my way or the highway, and they have strong personalities, and you mix them in with people that are more feeble, more quiet, more shy, more intimidated. You mix them with that. Who's going to win the argument? It doesn't take a genius to tell you who's going to win that argument. And a defendant's life rests on that. So think about that. A defendant's life rests on the principle of individual characteristics, individual strengths and weaknesses and traits. So you get a defendant who's innocent, but you have a juror or several jurors who are of weak character, who get influenced easily. They could be found guilty all because of that one little variable. Something you don't even think about. Something you can't even anticipate. When you're trying to pick a jury, you don't know what this person's all about. You don't know their beliefs. You don't know how strong of a character they have. You don't know if they're the bully or they're the ones who get bullied. You don't know these things. There's no way of knowing that. And again, I don't know. I would like to see that change. There should be some kind of system. Put somebody in there. Put a court officer in there, or Maybe the defense team could hire somebody to go in there, and the prosecution team could hire somebody to go in there. You have 1 and 1, so it's even. And they just sit down. They don't say a word. They're not allowed to say anything. The only time they can intervene is if they see somebody getting bullied or getting pressured. That's the only time they can intervene. Then maybe that'll stop it. But right now, nothing's going to stop that. From what I'm seeing, how it plays out, what this juror talked about, nothing's going to stop that. And then to show the arrogance on this jury foreman, he makes a point which should resonate with everybody. And just to go into briefly, I don't want to go into the whole story of this thing, but apparently there was somebody gave a testimony. This guy owned a shop. It was like a secondhand shop, I believe. And he gave testimony that this lady, Margaret, came in the shop and bought this trunk. It was like a large trunk, like a luggage trunk. It was like really large trunk. He gave testimony that she bought this specific trunk, which they then found the husband's body burned in. Which on a conceptual level, it doesn't even make sense because this lady was like 130 pounds. I think her husband was 200 and change. And they tried saying she killed him, put him in the trunk, carried the trunk outside, lit it on fire. I don't know how she'd be able to do that physically, but that's another episode, I guess. But my point is, this guy gave testimony that he sold the trunk to this Margaret. Flash forward to another guy they bring in. They actually brought in, I believe he was the partner of this secondhand store. And he said, no, we didn't sell her that trunk. We sold her this tiny little trunk. It was like the size of a briefcase. So it totally contradicted this guy saying that he sold Margaret the trunk she was found in. He didn't sell her that trunk. They sold it to somebody else. The guy was completely off, okay, is my point. I don't want to go down a path here where it gets convoluted. My point just is the guy's testimony that he sold her this trunk that the body was found in was not accurate. It never happened. He didn't sell it to her. The partner came in and disproved that. But here's where I want to focus on. This jury foreman, when they're doing this show, when they're doing Dateline, they tell him about they ask him, well, why did you believe that that guy sold the truck when they brought in the other witness who then said, we didn't sell her that trunk? Do you know that this juror said he didn't even remember that testimony of the second witness? And then he goes into, well, it's such a long trial, it was 2 months. And that's the point I want to make. I don't want to get into how incompetent this juror was. I want to get into the fact that he kind of gave a little insight to how these trials work. He talks about how it was 2 months trial and there was so much information and it was hard to remember. He didn't even remember in this guy testifying. The second witness testifying in opposition to the first one about selling the defendant the trunk. He didn't even remember that. How dangerous is that? Now, I don't even know how to counteract that. You have a jury who's not paying attention, I guess. He doesn't even know the witnesses that are coming in. And I want to play the excerpt from him because I just want to show how these things can be forgotten and the danger of that. Now, first, you're going to hear the host of the episode just giving an outline, telling the viewers that when they question the juror foreman about the witness that was brought in to counteract the trunk sale, you hear him say he didn't even remember it. So you're going to hear the host talking first, then you're going to hear the jury foreman. So I'm going to play that for you now.
The jury foreman about that testimony, he told us he doesn't even remember it.
But this is the first I'm hearing of this. You know, when you sit there for over 2 months and you have what you think are all the facts presented at the time, you don't like to hear later that the antique trunk dealer who said, I sold her that trunk, has been debunked. You don't like to hear that.
Now imagine that. He's saying he don't like to hear that. After sitting there for 2 months, he doesn't want to hear that the trunk dealer was debunked. Think about that statement. You have a juror who's deciding what he wants to hear and what he doesn't want to hear. Now, I tell you, when they tell you a jury of our peers are judging us, I don't know about that, because I wouldn't do things like that. And I'm sure 90% of the people wouldn't do things. I would hope 90% of the people wouldn't do things like that. So when you hear of a juror who does something like that, basically erases from his memory this testimony and admits, well, I've been there for 2 months. You just don't even want to hear it. You don't want to hear a witness debunking another witness. How devastating is that for the defense? You bring in somebody to prove opposite a supposedly strong witness that the prosecution have. You're able to show that it was not true, and you have a juror that completely dismisses that? How dangerous is that? But this is the reality, folks. This is what takes place. This is why people can't be under that delusion that everybody gets a fair trial. That's not the case at all. And everybody gets their day in court, and it's fair, and if you're innocent, you'll be shown innocent, you'll be acquitted. That's not true at all. Just look at all these different things I'm showing you now on one case. This is one example. And all these things happen in one case. You have a jury foreman who's intimidating other jurors. He's disregarding witnesses. It's been 2 months. He's tired. It's a lot of information, which I understand. But again, it goes back to the caliber of the juror. I understand if it's an 8-week trial, 12-week trial, these long trials. I understand it's overwhelming. But what's the alternative? You go on autopilot and somebody goes to jail for the rest of their life because you're incompetent? That's not the alternative. We have to do something to make sure these jurors that are picked are viable people, intelligent people, competent people who take it seriously to judge somebody, who take the system seriously, who understand their responsibilities. Not somebody who just wants to go home, not somebody who doesn't want to hear all the witnesses, or now says, oh, this is the first time I'm hearing this witness, when it isn't the first time. You were sitting on the jury, bud. You were there. You were there listening. I don't know what you're talking about. It's the first time. What do you got, amnesia? Were you taking a nap? Absurd. And that's how scary, but that's the reality of it. These are individuals that are serving on a jury, deciding somebody's fate, deciding if somebody goes home with their family or goes to jail. Now, if they're guilty, they're guilty, but you have to give them a fair trial. And if they're innocent and you're sending them to jail, you better check your conscience. I don't know how you'd be able to look at yourself in the mirror. You have to decide somebody's fate. You better make sure you're 100% certain in your decision. You can't zone out on witnesses. You can't not pay attention. That's why they give jurors notebooks. They have notebooks. They have pens. You got to write this stuff down. Okay, it may be 8 weeks, 12 weeks, whatever it is. Make notes of each day. What goes on each day, so when you're deliberating, you could remind yourself. It's a ton of information that you have to go through, that you have to revert back to. Make notations. Keep good notes. Keep accurate notes so you can relive that situation or that day's testimony in your head when you're deciding these defendants' future. When you're deciding if they're 100% guilty beyond a reasonable doubt, or you're contemplating if there is reasonable doubt, you better have your notes in order. You want to go through them one by one. I don't know how you can't. That's a huge responsibility. I wouldn't want to end somebody's life like that, take somebody's life away if they're not 100% guilty in my mind. I couldn't do something like that. But this guy blows it off like it's no big deal. I was there 2 months. I don't even remember this guy's testimony. Are you kidding me? You don't remember this guy's testimony? I wish I was in the jury room with this character. I'd put him right in his place, a guy like this. Loudmouth like that, talking nonsense. It's frustrating. You know, you hear these things and then you live through them and you see how these trials play out. It's frustrating. It really is. And the problem is nothing gets changed. This is going to go on in different courtrooms. There's going to be all jury foremen like this guy, jury members like this guy, jury members like that lady who caved. How do you fix that? And the only way to fix that, ladies and gentlemen, is by you fixing it when your time comes to serve on a jury. You're the only one who can fix it. You have to take these things serious. And I say it every time from my first episode. I'm not here to have people think the way I think or relate to things the way I relate to things. That's not the purpose at all. I don't care who agrees with me, who don't agree with me. That's not my goal here. My goal here is one thing. I just want to give the entire picture. I want to explain how things work. And I just want people who have an open mind, who are intelligent, who are here to understand maybe a different point of view. They don't have to agree with the point of view, but just to understand it, to understand where I'm coming from. There's plenty of times I may not agree with somebody, but I value their way of looking at it. I'll take it in, I'll contemplate it, and who knows, sometimes I may change my opinion. If they have a better way of looking at something, they have a more reasonable way of looking at something, a more intellectual way of looking at something, whereas I may be closed off without even realizing, and they open my eyes to that, I have no problem changing my perspective. And that's all I'm trying to do here, give an alternate way of looking at it, giving all the facts, explaining things in detail, and maybe have somebody say, you know what, I see it that way. I'm going to pay attention to that. I'm going to make sure if I'm ever put in that position, I don't allow these things to happen. That's the role here. That's the cause. That's the whole point of this whole podcast. And that's going to lead me into pretty much my final point. There was another show I was watching, and I made notes of this because this was, I think I saw it last week. I don't remember, but the one point I wanted to focus on was a detective, and I had a whole episode on this, and I've talked about this. It really goes back to the importance of having experts and rebuttal experts, and in this specific instance, it's about the cell site and the cell phone pinging. You know how they say, well, the cell phone pings off of certain towers, and you know exactly where that person's cell phone is, so you know exactly where their location is. And anybody who heard my episode, I don't remember the episode number, but I had 2 experts on in that field, in cell site technology. And it's considered a junk science in a lot of ways. But if you haven't heard that episode, just look through the past episodes. It's actually called cell site junk science, I believe. Listen to that because it's very informative. I had 2 experts in the field in it. Excuse me if you heard the snore in the background. Again, that's my dog. It's like 4 a.m. now, so he's out cold in the background. So I apologize for that if you heard that. But anyway, yeah, if you get a chance, just listen to that episode. But my point is, I'm watching this show, and now here you have the detective. This guy's involved. He had to do with that case, and he was tracking. They pulled the ping registry from the cell phone company, and he talks about that. And I just want you to hear what he says. This is coming from the detective now, so I want you to hear what he says about it. He's the one doing the investigating, so I want you just to hear what he says.
On occasion, when we receive that data, we notice that cell phones are actually not where they're showing to be. Sometimes the towers trip up, which means it sends a signal to a wrong location.
The bad news keeps on.
Okay, so here you have the detective admittedly saying that the cell towers could trip up and it sends the signal to an alternate location. Right there alone is a major problem. If it's sending signals to an alternate location and having somebody at an alternate location, how could it be relied upon at all? How do you know if that signal didn't get tripped up? You don't know. And that's why it is so important, and I did an episode on just experts and how important they are for the defense, but it is so, you hear things like that, and it's a no-brainer. If you're ever part of a trial where there are experts needed, where they're going to be presenting any kind of informational data, anything where there's a field of expertise and somebody with knowledge in that, you need to bring them in. If you're on the defense, you need to bring them in because you know the prosecution is bringing in their witness. If you don't bring in a rebuttal expert that's a big, big problem. If it affects your defendant and your defendant's the one that they're pinging and they're trying to get his location to tie in, to meet up, to triangulate, however they want to put it, you better be sure to have a rebuttal expert to show that side of it. You need the jurors to see. A regular individual isn't going to know these things. I wouldn't know these things. I wouldn't pay attention to these things if I wasn't involved in it, if I didn't have an interest in it. You hear one expert, you would just assume, oh, okay, he's an expert. He knows best. I guess it's accurate. You need to hear that other expert to show that other side of it, to cast a little bit of reasonable doubt. That's what it's all about. And that's what I'm appealing to here. And I spoke about this, ladies and gentlemen, a lot of times you'll be on the jury and you may only see one expert on the prosecution side, and you may not see it on the defense side. Do not assume that they didn't put the expert on because the prosecution expert was correct and the defense realized they couldn't refute that. Do not assume that, because the truth is, you need to be made aware, the judge could decide not to let experts in, so you don't know what took place. Or financially, maybe the defendant doesn't have the finances to call an expert. It's not in their budget. They can't do it. And even more importantly, maybe, as I pointed out, the judge didn't allow it. So please be sure, if you're ever serving on a jury and you don't see an oppositional expert for the defense, do not assume it's not there because of the fact that the defense agrees that the prosecution expert is irrefutable. That's not the case. There's so many variables that you may not be aware of. But just always keep in your head, for every expert, there's a rebuttal expert. And you're still only hearing one side of it. You could have 5 different experts get up there and they all have different interpretations. Think about it. Look it up for yourself. Whenever you see a study, right, like a new study comes out, I always like to do that for myself. I'll see a study. If I'm learning about a topic, I'll see different studies. I always try to put in an oppositional study. I want to see the other side. And then I try to find where the truth lies. What study holds more credibility? Who's behind the studies? You got to compare. You got to compare credentials. You got to compare it. You got to see which one holds more water, which one is more factual, which one is stronger. Just always compare those things. And it's the same concept with experts. You'll have one expert who interprets the information one way, and you'll have another who gives their side. That could show you flaws. That could show you that it's not as clear-cut as one expert's trying to make it. As the old saying goes, right, there's 3 sides to every story. His, hers, and the truth. You want to make sure you're hearing all the sides. If you're not hearing all the sides, question that. Don't give it all to the only side you're hearing. Don't give all of the credibility to the only side you're hearing. Don't put all your stock into that one side. Keep your options open. Think about why you're not hearing the other side. Think about the what ifs. That's all I'm saying. And the defense team, you have to do what you can to make sure you get those rebuttal experts. It really is a necessity to put on a proper defense. If I was an attorney, from the beginning, I would let the client know we need to budget for experts. If they're going to have an expert in DNA, we got to have an expert in DNA. If they're going to have an expert in audio, I want to bring in an expert in linguistics and how things could be misunderstood and contorted. If they're going to have an expert in cell site, I'm going to bring an expert in cell site. You got to really have that prepared and ready to go. It's a must to put on a proper defense. And whoever doesn't, they're making a big mistake. A big mistake. I've seen it play out. I've seen when different people don't put on experts that pertain to their clients. It's a mistake. You have to. You have to. When it pertains to your client, you got to bring that expert on. If you have other co-defendants, they're going to benefit from that. And you can't have your co-defendants can't bring on experts for you. If it's for your client, you got to bring on the expert. And it's just very important everybody's on the same page with that, because when you have co-defendants, everybody relies on each other, and it's very important. That's a very important piece of the puzzle. And again, I think today's episode accomplished the whole theme of what I'm trying to do here. I think I found it interesting. I found all the different topics interesting. I hope the listeners did. We're growing nicely. Got a lot of downloads. We're on a lot of different formats, a lot of different platforms. Oh, and I there's a website now. I put it out on social media, but you could go to jtppodcast.com and you could hear it on all the, you'll see all the available platforms the podcast is on. Stitcher, Amazon, Google, iTunes, Spotify, YouTube, of course, where it originated. But if you go to jtppodcast.com, it all comes up on there. You could even listen right on the site now. You could just listen to the latest podcast. The latest episode will always be featured on the site. And I think that's it for today's show. Thanks for tuning in. Until next time.
You've been listening to the Justice Tech Pros podcast with Dominick Crea, one of the most unique podcasts on the internet, discussing the obstacles the defense team faces when trying a case, what goes on behind the scenes during pretrial and motion phase, holding defense attorneys accountable, making sure they're fighting for their clients, the difference between textbook law and how things truly play out in a courtroom, and everything in between. We hope you've gotten some useful and practical information from this show, and we'll be back soon. Until then, find us on Twitter, Facebook, and Instagram at Justice Tech Pros. To email the show with questions and comments, it's podcast@justicetechpros.com. Till next time, this is Justice Tech Pros Podcast and Dominick Crea signing off.